recess appointments clause. We're going to have three people speaking today. We'll have Ronald Krotoszynski, who will be coming down to give the first speech. We'll have Josh Chafetz come down after him. And then we'll have a Q&A session, which our own Professor Curtis Bradley from Duke Law School will be moderating. So look forward to it. This is a very relevant and current issue since we have the Noel Canning case just coming out this past term. And look forward to what they have to say. So, Professor Bradley.
I'll join everyone in thanking Brett and Bill and the staff for organizing what I think has been a very stimulating conference. I also want to thank the faculty and students who have come for much of the day. I've seen a number of my colleagues as well as many of my students, and it's great to see the turnout. And of course, thanks to all the panelists and commenters for their work. The final panel, I think you'll find, follows quite naturally from the last one. We get a bit more specific, but we also have the advantage of focusing on a very recent and much talked about Supreme Court decision. You heard a little bit about it in the last panel, which is the Noel Canning decision. It concerns a clause in the Constitution called the Recess Appointments Clause. I'll just read it because this short clause, this text ended up being a big feature in the decision. It says that the President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. And the Supreme Court had to interpret that clause in NLRB versus Noel Canning last term. And an opinion by Breyer, joined by 4 other justices, the court read the clause to give the President broad appointments power during recess, both to include breaks in the Senate that occurred during the yearly sessions of the Senate, and not just in between the yearly sessions of the Senate, and to apply the appointments power even to vacancies that predate the recess. So accepting both of the arguments by the President for the broader reading of the clause, still holding against Obama in the particular circumstances of that case, because the court also said that presumptively a break in the Senate business needs to be at least 10 days in order to constitute a recess for this purpose. And the Senate had been holding pro forma sessions. You may hear more about that in the discussion. And the court was satisfied that was enough to disrupt the break and therefore render it not long enough for a recess for appointments purposes. That was 5 justices. 4 justices concurred in the judgment. So Breyer wrote the majority opinion. Scalia writes a concurrence in the judgment and disagrees with the broad reading of the clause and significantly disagrees with the methodology of the majority. The majority puts a great weight on historical practice of how the appointments process has worked over time, particularly modern appointments practices, even if it seemed to deviate to some extent from 19th century appointments practice. Scalia and the other 3 concurrers disagreed with putting so much emphasis on practice to interpret the clause, accusing the majority of allowing a type of adverse possession of presidential power just by virtue of practice over time. And so it was extensive debate over methodology as well as the bottom line, although the Scalia concurrence agreed that, in fact, Obama should lose that particular case, but for broader reasons. So our 2 panelists will discuss the Noel Canning decision and also other issues about recess appointments. Let me just say a couple words about our 2 panelists. Ronald Krotoszynski is the John Stone Chairholder of Law at the University of Alabama Law School. He's sort of back home today because he's a Duke grad, a JD and LLM grad from Duke. He has written widely in the constitutional law area, including about separation of powers, but also privacy, First Amendment. Just to note, one of his many publications, he published a book in 2012 called Reclaiming the Petition Clause, Seditious Libel, Offensive Protest, and the Right to Petition the Government for a Redress of Grievances. I didn't really know Ron, but he and I were sort of talking yesterday and realized we had been both in the same law firm in Washington, D.C. for many years in the 1990s, reminding us of what an intimate place it really was. His main paper, which he'll present, is entitled Transcending Formalism and Functionalism and Separation of Powers Analysis, Reframing the Appointments Power After Noel Canning. And the commenter is Josh Chafetz, professor at Cornell Law School. His many distinctions include having studied at Oxford as a Rhodes Scholar. He's much newer to academia as compared with Ron, but he's already been writing widely, including extensive writing about Congress as an institution, and he's currently working on a book entitled Congress's Constitution, Legislative Authority, and the Separation of Powers. I've had the pleasure of getting to know Josh at a variety of conferences over the last year or 2, And I sometimes think of him as the only person left in America who still likes Congress, and you may hear some of that perspective today. So Ron will speak for about 20, maybe to 25 minutes, and then Josh will speak for about 10 to 15 minutes. Time permitting, I may ask them a question or two, and then, of course, invite questions from the audience. Ron.
Well, thank you for that very generous introduction. Let me begin by noting that it's good to be back at Duke. Let's go Duke, parenthetically. Indeed, if anyone has a spare ticket to Notre Dame tomorrow at 1 o'clock, let's talk. More seriously, let me express my sincere thanks to Bill O'Connell, Brett Schroeder, and all their editorial colleagues at the Duke Law Journal for their dedicated work on making this important symposium a reality. As it happens, when I was a law student here at Duke, I served as an articles editor on the DLJ, and my portfolio many years ago, I'll add parenthetically, included the Annual Administrative Law Symposium. Accordingly, it's particularly meaningful, special in fact, to be back at Duke Law School for this important event. I'm deeply grateful, and so to repeat, I'm very thankful to the editors for calling me home. So I will spare you the alma mater and or the fight song. I did consider painting my body blue for this talk, but I thought that might be going just a tad too far. So more seriously, let me get down to business. So let's begin. And for me at least, the role of text in separation of powers analysis is sort of teed up front and center in the Noel Canning decision. And I think everyone agrees, or almost everyone agrees, that text matters. I suppose the most obvious asterisk or footnote would be Bruce Ackerman, who doesn't place much relative weight on text over practice. But for the most part, most people engaged with administrative law matters and separation of powers doctrine think that at least some attention has to be paid to the text. Formalists in particular privilege text. Originalist formalists, originalist textualists, I should say, are a subgroup of formalists, and they privilege it in nearly absolute terms. On the other hand, pragmatic formalists use text as a starting point, but not an ending point. Functionalists, on the other hand, generally consider text irrelevant, but seldom controlling factor. But even most committed functionalists, and certainly principled functionalists, would readily accede to the proposition that one has to take account of constitutional text. Peter Strauss comes to mind in this regard. He uses text to help set the metes and bounds of discretion, but is not inexorably opposed to innovations in administrative design and structure, like Professor Metzger, I suppose, as well. Now, John Manning, a pragmatic formalist, has proposed fairly famously in a recent Harvard Law Review article, looking to the specificity of a constitutional commitment when determining how to enforce, or when courts go about enforcing the separation of powers doctrine. Manning argues that specific text should be strictly enforced. So an example he gives are the bicameralism and presentment clauses of Article 1, Section 7. The Constitution sets forth a very specific procedure for a bill becoming a law, has to pass both houses, has to be presented to the president, and for Manning, that's that. So he's broadly in favor of a decision like INS v. Chadha, which fairly strictly enforced the bicameralism and presentment requirements. On the other hand, and by contrast, however, he argues that more general constitutional provisions should not be strictly enforced by the courts. And the example he gives there, and to be fair, he does hedge a bit, are the vesting clauses, Article 1, Section 1, Article 2, Section 1, Article 3, Section 1, vesting legislative power in Congress, executive power in the President, and judicial power in the Supreme Court and such inferior courts as Congress decides to establish. In his view, courts should not strictly police these more general clauses. Instead, courts should be more deferential to the political branches, to the President of the Congress, when only these generic, fairly broad assignments of power are at stake. And in that sense, then, he rejects the position of folks like Gary Lawson and Stephen Calabresi, who would use the vesting clauses as a basis for invalidating innovation in administrative design and structure. So John and Manning's theory is fairly easy to apply, I think, when only a single constitutional clause is in play. But what if more than a single clause seems relevant to a particular dispute? And it seems to me there are actually three possible scenarios we could imagine in terms of these conflicts. Two general clauses, a general clause and a specific clause, and finally, two specific clauses or more. Well, the first typology is easy. If you have two general clauses, a general and a general is still a general, and so Manning, I assume, would say that the court should be deferential to Congress and the President. A general and specific clause conflict is easy as well. The specific should take precedence over the general. The court would be justified in enforcing the specific clause, but would lack legitimacy in trying to impose limits incident to a general clause. But where the sledding gets a little rough is where you have two or more specific clauses. That seems to me to be the hardest kind of conflict. And Manning's theory would seem to require judicial enforcement of both. But how is a judge to choose which commitment to enforce, particularly when advancing one constitutional commitment comes directly at the expense of impeding the other? When a conflict between specific clauses exists, textual analysis won't provide a clear answer, no matter how many times you reread the text. It can't because the framers intentionally blended rather than separated powers. A great example of this, I think, is the President's Commander-in-Chief power in Article 2 and the Congress's Article 1, Section 8 power to declare war. You have very impassioned arguments by presidentialists and congressionalists as to the limit with respect to unilateral presidential action in the context of using or committing military forces, particularly to offensive operations abroad. But no matter how much they slap the podium or stomp their foot, no matter how much they invoke this statement or that from the Federal Convention in Philadelphia, the framers plainly blended these responsibilities. If I had a chalkboard, I'm kind of old school, and I drew a Venn diagram, there would clearly be an overlapping part of the Venn diagram in which the commander-in-chief power overlaps with and overlays the Congress's war power. So how should courts police the boundary? Moreover, should they even attempt to police the boundary at all? Maybe where there are conflicting specific powers, the best result would be for them to exit the field, declare it a political question, because there's no textual basis for resolving the conflict. Interestingly, the originalist, textualist, formalists, that's a mouthful, don't seem much inclined to take that solution, that is to say, to exit the field because there's no principled reason for preferring one clause to the other. So this sort of sets the stage in a general way for my project. To cut to the chase, I believe that ambiguities involving conflicting specific clauses should be resolved by courts and should be resolved by recourse to settled conventions over time, provided those conventions seem reasonably to accommodate the conflicting values. Let me shift gears a bit and talk very briefly about Noel Canning and the Recess Appointments Clause. It provides, I think, a useful window into these issues. Noel Canning involves the recess appointments made by President Obama during a period of time when the Senate was conducting pro forma sessions every 3 days. The House refused to acquiesce in a recess of the Senate, and the Constitution requires that both houses agree if they're going to rise for more than 3 days. It also says the President actually can adjourn them if they disagree, and not much has been done with that. It would be interesting to see what would have happened if President Obama, assuming Harry Reid for the Democratic majority in the Senate insisted on recessing and John Boehner for the House refused to acquiesce, if in fact the President could use that power. To the best of my knowledge, the power has pretty much lain dormant since it was put into the Constitution, but perhaps Josh can correct me if I have that wrong. He would know better than I the history of that particular device. So at the D.C. Circuit level, a panel there held that the Appointments Clause had been, or the Recess Appointments Clause had been violated in this instance, and wrote a very arguably breathtakingly broad opinion. First, the vacancies on the NLRB had not arisen during an intersession break of Senate sessions between the first and second sittings of the contemporary Congress. The court said that the word arise meant that the opening or vacancy had to come into existence during an intersession as opposed to an intra-session break of the Senate. Second, only intercession recesses implicate the Recess Appointment Clause. So simply having an adjournment during a session would not be an occasion for the President to use the Recess Appointments power. Now, the Supreme Court, as Kurt Bradley indicated, affirmed the D.C. Circuit ostensibly 9-0, but I like the way he phrased it. It's really a 5-4 decision. The opinion by Justice Scalia for 4 members of the court is only nominally concurring. He rejects almost entirely every aspect of Justice Breyer's analysis. So it's a nominally concurring but really dissenting opinion. It's definitely the wolf in the sheep's clothing in terms of joining the reasoning of the majority. Breyer wrote for the majority. The majority held that the Recess Appointments Clause power extends to vacancies regardless of when the vacancy comes into existence. Doesn't matter whether it's intra-session or inter-session. And moreover, that the President may use the recess appointments power during both inter- and intra-session recesses. However, he added an important caveat. A recess of less than 10 days is presumptively too short to count. This led Justice Scalia into a fit of apoplexy because there's nothing in the Constitution's 4 corners that says 9 days is too short and 11 days is just right. Instead, Justice Breyer derived this from fairly consistent practice across presidential administrations. There are a couple of examples of recess appointments where the recess had been less than 10 days, but they were very much exceptions in Justice Breyer's view that proved the general rule. So because the Senate had been sitting, albeit in a pro forma way, every 3 days at the time the NLRB appointments were made, ostensibly under the Recess Appointments Clause, the session breaks were too short to trigger or make applicable potentially the Recess Appointments Clause. Accordingly, Justice Breyer, for 5 members of the court, concluded that the appointments were unconstitutional, that the President had not lawfully invoked the Recess Appointments power. Justice Scalia, in the opinion that I will characterize as only a nominal concurrence and effective dissent, would have embraced the D.C. Circuit's reasoning pretty much in total, as well as its result. So for Justice Scalia, a strict reading of the Recess Appointments Clause indicates that it's only to apply to intercession recesses, and even then only to vacancies that come into existence during intercession breaks. So, stepping back and looking at the decisions, the opinions more broadly, it struck me and strikes me today that Noel Canning is a formalist decision. Both the majority and nominally concurring opinions are primarily textualist in orientation. The most important, I think, line of departure is that Justice Breyer relies on Article 1, Section 5 to find that the Senate may determine for itself when it is in session, absent fairly extraordinary facts or circumstances that he doesn't identify but says might exist, whereas Justice Scalia relies on a very close reading of the Recess Appointments Clause's text to find its scope is remarkably narrow and frankly largely irrelevant in the modern era, when the Senate is more or less constantly in session. A functionalist opinion, I think, would have engaged the constitutional text to a much lesser degree and the politics and the practical realities of the appointments process a great deal more. Peter Shane, for example, of the Ohio State Law Faculty, has written law review articles, op-eds, essays, sketching a variety of functionalist approaches to the recess appointments question and to the general problem of staffing executive offices when the Senate will not reliably and on a timely basis process presidential nominations. In Shane's view, presidential self-help should be deemed permissive if the political process is broken. Matthew Stevenson of the Harvard Law School faculty has argued in the august pages of the Yale Law Journal that inaction on the part of the Senate with respect to principal executive offices should be deemed the equivalent of consent. Robert Bolt's play, A Man for All Seasons, gets some wonderful footnote action there. In fact, as you may recall, if you've seen the movie, Thomas More, when being questioned by Cromwell, says that the maxim of the common law is that silence implies consent. Stevenson actually cites this in the Yale Law Journal article to say if the Senate gets the nomination, good faith efforts are made to process it, nothing happens. After some period of time, it's good enough for government work. That's a much broader recipe for self-help than even Peter Shane has advocated. Peter Shane also suggests that decision avoidance techniques might well be, and wisely might be, deployed by the federal courts in the context of disputes over staffing executive branch offices. For example, he says courts might find that challenges to recess appointments could be dismissed on standing grounds, the idea that the plaintiff lacks standing, or perhaps as political questions. His argument at base is that the courts should leave Congress, the Senate particularly, and the President to fight it out between themselves without intervening. And, you know, in fairness to Professor Shane, he really does make a good case for the proposition that interestingly, the vesting clause of Article 2, Section 1 and the take care clause of Article 2, Section 3 require that the President have some ability to enforce the laws that Congress enacts, and that if the Senate will not reliably confirm principal and inferior officers, the President has to do something, elsewise laws go unenforced and the President is engaged in unconstitutional behavior. Laws that he has a duty to ensure the faithful execution of don't get executed. I should note, too, that Noel Canning is part of a larger move or embrace of formalism under the Roberts Court. Professor Metzger talked at length about Free Enterprise Fund. That's probably the poster child, I think, for this move. But Stern v. Marshall provides another salient example, as do other recent cases involving the scope of bankruptcy court powers to decide common law claims integral to bankruptcy proceedings. I think one could score Noel Canning as part of a larger project to strictly enforce textual limitations on Congress's ability to create novel, innovative administrative structures and procedures, even if the procedures or structures are convenient, efficient, and even if the formal limitation does not demonstrably actually advance in the real world the values that it purports to take into account. I will note as well that Justice Breyer needed Anthony Kennedy's vote to get to 5. Justice Kennedy has been a pretty reliable co-traveler with Chief Justice Roberts in these opinions. And one might wonder, why did Justice Kennedy sign off on the Breyer opinion? And I suppose we could ask him. I think he's unlikely to answer the question. But my guess is precisely because, in a significant degree, the Breyer opinion is formalist in nature. At the end of the day, it relies on a textual analysis of Article 1, Section 5 to say that the Senate can essentially decide for itself when it is in session, and that courts should be deferential to the Senate's determination that it is, in fact, ready, willing, and able to receive, consider, and vote upon presidential nominations. Now, again, I want to go back to this notion of conflicting clauses, and it seems to me that Noel Canning did present, at least in my view, a conflict between two specific clauses. Article 2, Section 2, which requires the Senate's advice and consent to all principal officer appointments and to inferior executive officers unless by law Congress provides for direct appointment by the President alone, by the courts of law, or by the heads of departments. And Article 2, Section 3, the Take Care Clause. One might also toss in the opinions clause as well. If there's no one minding the store, you can't really get an opinion from an absent officer. So there are clearly provisions of Article 2 that presuppose the President will have access to and the ability to call upon principal officers. At the same time, though, the Constitution has another competing textual commitment which conditions the appointment of executive officers on the Senate's advice and consent. It seems to me one can't zero out, as arguably President Obama did, the Senate's role in the advice and consent aspect of appointments. At the same time, President Obama had a pretty good claim that he has a right to subordinates to ensure the faithful execution of the laws, and if he wanted to seek an opinion from a principal officer head of a department. So how should a court resolve this conflict, attack this dilemma? And as between Breyer and Scalia's dueling Noel Canning opinions, who has the better argument? My position is that practice and convention probably should serve as a tiebreaker when specific text points in conflicting directions. And what do I mean by this? Well, Justice Breyer used practice to inform the scope and meaning of ambiguous text in the recess appointments clause itself. By way of contrast, Justice Scalia used dictionaries. Justice Breyer's approach, to me, has more to recommend it because it seems to me less subjective and more empirically grounded in a way that lends, I think, greater legitimacy and more persuasive force to his opinion. In the absence of a textual command or in the presence of a textual ambiguity, courts lack an obvious or compelling predicate for imposing an outcome on Congress and the President. The work of scholars like Kurt Bradley, Adrian Vermeule, and Trevor Morrison suggests that recourse to consistent practice, or as Vermeule calls them, conventions established over time and consistently recognized and enforced, might be the best way forward in resolving these complicated separation of powers problems. And I have to say that seems right to me. Another cut would be perhaps Mike Dorff and Neil Buchanan's proposal for requiring the use of the least unconstitutional option, where all of the options lead to some sort of constitutional problem. Buchanan and Dorff were writing in the context of the debt ceiling limit. Congress spends money, Congress authorizes a debt, then Congress refuses to raise a debt ceiling, which Congress also imposes. So Congress issues conflicting commands to the President. The President simply can't honor all of them concurrently, given the facts and circumstances that exist when we hit the debt ceiling. And so Buchanan and Dorff argue that the President has a duty to try to do the least damage, to pick the option that least aggrandizes the executive branch, that's most easily corrected by the legislature or the courts, and that most fully and completely discharges as many of his duties or her duties, as the case may be, as possible. And it seems to me that behavior or actions consistent with well-settled conventions or practice should be generally deemed less unconstitutional than those that are not. Some caveats should apply, notably including whether the practice or convention enjoys broad and voluntary acceptance by the other branches. In a fairly influential article by Kurt Bradley and Trevor Morrison, they argue that we shouldn't allow conventions to automatically receive deference if, in fact, Congress has been bowled over, as it were, by the executive. You would want to look for evidence of voluntary acceptance of the convention rather than simply an inability, because of collective action problems, to resist it. I would also note, and I hesitate to say this as I'm sitting there, I read Bradley and Morrison to not start with conventions, but to sort of propose what I suggest, which is what they suggest and I embrace, that's maybe a better way of putting it, they were there first, that you start with the text, but where the text doesn't yield a clear answer, looking to convention or consistent practice makes sense, provided the practice or convention is legitimate, that it's not unilaterally imposed by one branch at the expense of another. So in a sense, I think I'm proposing, and I hesitate to say this word, but how could it be an administrative law symposium when no one drops the C word? And by that I mean Chevron. So what yes, had you, didn't I? The blue paint, anyway, back to business. What I'm proposing, I think, is a kind of Chevron for the separation of powers doctrine. Start with the text. If it yields a clear answer, we're done. The Senate gets to determine how to try an impeachment. Article 1 gives the Senate the sole power to try impeachment. See Nixon v. United States. In fact, Chief Justice Rehnquist says it's a political question. The President may not superintend or write for the Senate trial rules for an impeachment. To give you another example, I would argue Article 1, Section 7, the bicameralism and presentment clauses, are pretty clear on their face. There's really no need to pull out a Webster's or OED circa 1787 or 89 to get a handle on what bicameral passage and presentment to the President means. Where text is vague, where text contains conflicting priorities, however, courts should look to practice over time to inform meaning, rather than impose a solution of their own making, provided that the historical practice represents a reasonable accommodation of the constitutional conflict or of the ambiguous text. The Breyer opinion, it seems to me, hits these metrics and hits them pretty well. And it is therefore preferable, in my view, to Associate Justice Scalia's opinion in Noel Canning. I should mention, too, I suppose, that I am sympathetic to the criticisms that Professor Metzger made earlier of Justice Breyer's opinion. Mike Dorff, by the way, sent me an email saying much the same thing. He does a great job of engaging the Senate's unilateral power under Article 1, Section 5 to decide when it's in session. And it may well be that simply ignoring advice and consent is self-evidently not the least unconstitutional option. But the Breyer opinion does very little to address the practical difficulties that the president faces in light of the endemic vacancies that plague the executive branch, including key executive branch offices. And in some respects, a little more dicta rather than a little less dicta might have been helpful in terms of laying out some ideas regarding alternative self-help measures that might be constitutional. If you're going to have a dicta party, you might as well go all the way in for a dime, in for a dollar, or in this case, it's more in for a dollar, in for a dime. So I think taking up in dicta innovation and the political reality that frames the dispute, the context of the overall dispute that led President Obama to resort to this self-help would have enhanced the persuasive authority and credibility of the opinion, and perhaps provided for a more balanced analysis of the larger problem in context. It seems to me something short of ignoring the Senate's advice and consent role might well work. For example, reallocating duties and appointing a West Wing czar or overseer or minder over a cabinet-level department might allow the president to oversee state or defense or the DOJ in the absence of an attorney general or even a principal subordinate officer within those branches. That might violate a statute. A statute might say that a particular power is to be exercised by the attorney general if you've got an acting officer or a subordinate with someone in the West Wing sort of supervising them as a czar or a minder. You have done a constitutional harm, but I would argue that it's a lesser constitutional harm than not achieving a statutory objective which Congress has put into the U.S. Code in the first place. I also think that this general approach to resolving constitutional conflicts can and should be applied more generally and not just in the context of the Recess Appointments Clause. It seems to me, again, because judges can point to something extrinsic to their own subjective values or political preferences or ideology, they can point to actual practice over time, which is something that's empirically verifiable, that this provides a less subjective basis for resolving these intractable separation of powers problems, and therefore, in my view, would lead to more acceptable, more legitimate judicial decisions. Certainly, the potential scope of judicial power would be reduced, and if I recall Chief Justice Roberts correctly from his confirmation hearings, he's a modest judge. He's just calling balls and strikes. Well, as between hauling out dictionaries, which you subjectively select, and picking the definition that best suits your subjective outcome, and looking to consistent practice over time, which both branches have voluntarily acceded to, it seems to me the modest judge should go with the latter and not the former. So, I'll try to sum up. I think in conclusion that Noel Canning is a formalist opinion, but its embrace of practice over time to inform text, the text of the Recess Appointments Clause, has much to recommend it. It is, I think, as Professor Metzger suggested, a kind of blended opinion that involves, I think, at its heart, a formalist ideology because it is textualist, but at the same time, a fair amount of practical wisdom as well. It is a pragmatically formalist opinion. It is not an originalist, textualist formalist opinion. In important ways, I think, Noel Canning transcends, in fact, the dichotomy of formalism and functionalism in seeking sensible and pragmatic answers from a document, the Constitution, which does not and cannot provide them, because in this particular instance, the framers blended rather than clearly separated powers. The Senate is to have a role, but the President is supposed to oversee an effective, vigorous executive branch. Formalism, shackled to textualist originalism, simply does not work unless one seriously believes that government by 18th century dictionaries is superior to giving decent respect to consistent practices between the political branches over time. Pragmatic formalism, on the other hand, can and should incorporate consistent practice over time where text is ambiguous or contains conflicting mandates. Convention ought to play some role when enforcing the separation of powers in the context of an ambiguous or conflicting set of constitutional mandates. So I think that's a good place to stop. Why don't I do that? Thank you for your time and attention, and let's go Duke.
So thank you, Professor Krotoszynski. We'll have Professor Chafetz come up now and talk to us. I think we've been very good about staying on time so far today. I think at this point maybe we should push back the Q&A session until about 5 minutes before 4, just to ensure that we don't cut you off, Professor Chafetz. And I think that should still be just fine. We'll move on to Paul Light at 4:15. Thank you.
Well, I know every late-in-the-day speaker at a conference from the beginning of time says this, but I will actually try to be brief. I want to start, though, by echoing the thanks that everybody else has already expressed to both the symposium organizers, all the people who put in so much hard work on this, and also to all of you for coming, to Kurt for the very nice introduction, and also to Ron for giving us a really interesting paper, something sort of with a lot to sink our teeth into. So Ron essentially has written and presented us today with a very interesting both reading and defense of the Breyer opinion in Noel Canning as representing sort of a third way between formalism and functionalism, which Ron calls pragmatic formalism, right? A method that begins with formalist tools, seeking answers to tough questions using the sort of standard textualist toolbox. But if that toolbox can't get us all the way to a determinative answer, the pragmatic formalist then turns to historical gloss or proposivist tools to guide the inquiry the rest of the way home. In this way, Ron suggests the pragmatic formalist avoids the pitfalls most commonly associated with the two sort of more widely subscribed to approaches to separation of powers, right? Formalism on the one hand and functionalism on the other. So as Ron writes in his draft, strict formalism presupposes that the text invariably offers clear answers, despite the fact that this is not always so. On the other hand, functionalism tends to undervalue the importance of the text where the Constitution does offer clear rules of the road. In Ron's view, the right response to this sort of dilemma is the pragmatic formalist two-step, right, where you first exhaust the potential of formalism and then you turn to other considerations once you have, in fact, exhausted those potentials. Well, at the risk of perpetuating a deleterious cycle of way inflation, I want to ask whether there might not be a fourth way to view the separation of powers. And in particular, and this, I think, picks up on some of the themes that Jillian mentioned, although with a somewhat different twist on them, I want to ask if there isn't a way to bring politics back in a very significant way. Of course, I say I want to ask that. I don't actually want to ask that. As Kurt mentioned, I'm writing a book on this, so I want to assert that, in fact, there is a way to bring politics back in. So let me try in a sort of very abbreviated way to suggest what such an approach might look like and how it would apply to some of the issues that animate Ron's very interesting paper. So unlike standard formalist accounts, I think a political account of the separation of powers wouldn't suggest that the text invariably offers clear answers as to the constitutional distribution of powers, or that that distribution remains constant across time. But unlike standard functionalist accounts, it wouldn't suggest that there's some theoretically discoverable optimal distribution of powers, brooding over us omnipresently, and that all we need to do is figure out what institutional designs and procedures will get us to that optimal distribution. And unlike Ron's own account, a political account would focus not simply on the interactions between government institutions or on the settled conventions over time that they come up with, but rather on the interactions between those institutions in the governing structure and the public that they purport to represent and work for. In short, a political account, what in my book and in other writing I've called a multiplicity-based account, suggests that political power is largely endogenous to politics, that our written capital C constitutional structure is actually quite thin, and that most of what it does is provide the tools with which the branches contest with one another continuously across time for decision-making authority in the specific context of specific live political controversies. So for example, I disagree with Ron that the take care clause or the opinions clause give the president any claim to have subordinates confirmed, right? In my view, you want to take the thinnest possible reading of these and every constitutional provision. The take care clause does nothing more than impose a duty on the president, not even a duty to faithfully execute the laws, rather, by the way, a duty to try his best, right, to take care that the laws be faithfully executed. And the opinions clause simply gives him a right to opinions from whatever subordinates he may have, right? Nothing in the Constitution gives him the right to any particular subordinates. And it would be strange if they had meant to include a requirement that he be given specific cabinet officials, but just forgot to write it down. So my view is, again, you want to take a thin reading of those. Now, these sort of live political disputes that arise then are settled locally as one-offs, and although they certainly alter the playing field for future disputes, They don't, contra to Bradley and Morrison, give us global binding settlements of large separation of powers questions that will hold good for all time and that can actually constrain us in a principled way in the future. This means that the distribution of small c constitutional power is dynamic, not static, and that its dynamism occurs not with reference to some abstract notions of who's best suited to wield some particular power, as the normal functionalist account might have it, but rather with reference to the surrounding politics of the day. To the extent that this is a good thing, as I think it is, it suggests that I disagree with Ron when he writes that a clearly provided textual resolution within the four corners of the Constitution itself is always necessarily the first best way to solve a separation of powers conflict. I think clear text is one good way sometimes to solve these conflicts, but I don't think we would want to have a text that specified everything in the thickest possible way if that were a practical alternative. I think even if practical, it would be undesirable. So for example, to pick up on a theme that we talked about quite a bit this morning, levels of deference on nominations vary significantly over time. And this is not a sort of linear story about a progression from a sort of mythical, wonderful past where everyone got along really well to a horrible, destructive present where everything is obstructionist. Right? So it came up this morning, right, the fact that Washington's nomination of Rutledge was voted down the second time. Andrew Jackson, after losing significant numbers of seats in a midterm congressional election, tried and failed twice to get Roger Brooke-Taney confirmed to various positions. He nominated him as Secretary of the Treasury and was shot down. He nominated him as Associate Supreme Court Justice and was shot down before he finally, after another intervening election, successfully nominated him as Chief Justice. And of course, we all know that went very well. The reason that Taney was shot down both times, by the way, was because of a policy dispute. It was because of the blending of policy and personnel. He was denied confirmation as Secretary of the Treasury and again as an Associate Justice of the Supreme Court because he, as acting Secretary of the Treasury, had been the one who carried out President Jackson's orders to withdraw federal funds from the Bank of the United States, a policy that was widely opposed in Congress. Likewise, John Tyler, the first president to come to office because of the death of the president, right, William Henry Harrison's death. Tyler was a Whig essentially out of spite for Jackson. He didn't so much believe in Whig principles as hate Jackson. So he became a Whig. He was the vice president. Harrison dies. Tyler is almost immediately called his accidency by his own party. Within a couple of months, the Whigs expel him from the party, right? They expel a sitting president from his own party. And he has something like a 40% success rate over the course of his presidency in getting nominations confirmed, right? I don't have to say much about Andrew Johnson's history with getting nominations confirmed. In 1958, Eisenhower tried to get his close friend Lewis Strauss confirmed as Secretary of Commerce and failed to do so. Right? What all of these have in common is that they were fighting against the politics of the day. Right? Washington was in his nomination of Rutledge fighting against a Federalist-dominated period Congress that was a big fan of the Jay Treaty. Jackson was fighting against congressional majorities that were actually at that point fans of the Bank of the United States. Tyler was fighting against both his own party and the Democrats. Everybody hated him, right? Johnson, again, the second president to come into office because from the vice presidency because the president died. Johnson was, of course, fighting against everyone as well, right? The Democrats had no particular use for him as a war Democrat, and certainly the Republicans had no use for the Democrat who'd become president simply because their hero, Lincoln, had been assassinated. Right? Eisenhower tries to get Strauss confirmed in the midst of the beginning of the 1960 election process to replace Eisenhower. Right? All of these are facing unfavorable political landscapes, and they fail to get their nominees through. At other times, of course, when the president is riding high, or the Senate isn't riding high, or there's widespread agreement about particular nominees, then they sail through, right? This isn't a linear story. This is a story about how confirmation politics are politics like everything else. They're subject to the same political pressures, and those political pressures aren't just in Washington. They're between people in Washington and the general public. Okay, so let's bring this now to recess appointments, the topic that Ron's given us. First, I think a politically sensitive approach to the separation of powers would note what actually gave rise to the facts of Noel Canning, the filibuster. Right? We talked about this a little bit, actually a good bit with Anne's paper this morning, but Ron basically really only mentions it in passing. Right? But the reason that Obama takes this unusual step is because his nominees are being filibustered, not because they're being voted down. Now, the fact that these nominees are filibustered and not voted down, that is, the fact that the problem here is minority obstruction, was actually hugely consequential for the constitutional politics of the moment. And this is something that becomes apparent to us when we start looking at the discourse between the elites, the political elites, and the public, rather than simply the discourse among the political elites. So an illustration of the role that the filibuster played, as an illustration of that, consider the following contrast. So when his nominees are filibustered, Obama is willing to put forward what amounts to a fairly strained argument that he could unilaterally decide when the Senate was in recess and when it wasn't. Right? In justifying that move, he goes public. He sends his subordinates to go public. He sends surrogates to go public. And they have a pretty common hymnal, which is, the Senate won't even give my nominees an up or down vote. And that justifies this. Right? He doesn't talk about, I deserve to have these nominees confirmed. What he says is they deserve a vote. And that works in the public sphere. And that's why, and his confidence in the fact that that will work, is why he is willing to put forward this strained interpretation. By contrast, when the House, the majoritarian chamber, is refusing to pass a clean debt ceiling increase in 2011, a number of commentators urged Obama to rely on equally strained arguments about his unilateral authority to lift the debt ceiling, whether this is the 14th Amendment argument, or Jack Balkin's magic platinum coin argument, or any of the other things that we heard at the time. Right? But Obama refuses to rely on those arguments in that context. And in fact, he says at a press conference, Americans made a decision about divided government. The implication being that he was bound to respect that decision in the majoritarian context of the House. Right? He didn't feel like he could go public with a claim that this House majority that you guys, the American people, just elected, is standing in my way, so I have the right to roll over them. But he did think he could go public with the claim, this tiny minority in the Senate of 43 people is standing in the way not only of me, but of the other 57 senators, and therefore I have the right to roll over them. Right? Obama's decision to push the boundaries of the recess appointments power, then, was enabled and conditioned by the surrounding political circumstances. And likewise, filibuster reform for appointments in 2013 then significantly de-escalates the fight over recess appointments before Noel Canning comes down. Right? Noel Canning is certainly not entirely, but in some sense, also a somewhat anticlimactic decision, not quite the nothing burger of Peekaboo, but a bit anticlimactic because by the time it comes down, the NLRB is full of confirmed appointees because of filibuster reform. And indeed, of course, it's interesting to note that if filibuster reform had come earlier, the DC Circuit's maximalist opinion may well never have happened because one of the first things that happened after filibuster reform is the confirmation of 3 Democrats to the DC Circuit. The fact that Obama and the Senate Democrats were able successfully to make a public case against minority obstruction, combined with the significant pro-Democrat results of the 2012 election, then were far more consequential to the question that I suspect is the one that actually we care about, which is who staffs appointed offices, than anything that Stephen Breyer might have had to say about the matter after filibuster reform was already a fait accompli. And yet, in Ron's paper, nothing seems to turn on whether or not the nominees were filibustered or voted down by majoritarian procedure. Right? On Ron's view, the president's inability to get his nominees confirmed threatens to undermine the Take Care Clause, or at least his thick reading of the Take Care Clause, and possibly the Opinions Clause as well, whether the president's failure results from disagreements with the Senate majority or obstruction by a Senate minority. Now, this seems to me to be, unfortunately, inattentive to the political factors that necessarily condition the way that those conflicts play out. So one question that I think I would put to Ron is Obama's need to get his appointees confirmed as pressing today if the Senate votes them down as it was 2 months ago if the Senate simply refused to hold a vote, or 2 years ago before filibuster reform, if the Senate simply refused to hold a vote on them? And if not, why not? Why doesn't it call into question exactly the same conflict of constitutional values? So consider, as my sort of last point, an alternative defense of the outcome in Noel Canning. And this picks up actually on something that Ron mentioned in his talk, and that I think is more attentive to the surrounding politics of the day. And this is to consider the recess appointments clause in conjunction with the adjournment clauses, which Ron mentioned. In some sense, this may represent a sort of Gillian-like innovation in separation of powers, although that would be somewhat ironic, since, of course, this innovation comes from relying on a piece of constitutional text, fairly clear piece of constitutional text, although one that, as Ron was correct to point out, has never been invoked in American history. So under Article 1, Section 5, Clause 4, neither House of Congress can adjourn for more than 3 days without the consent of the other. But under Article 2, Section 3, if they can't agree on when to adjourn, the president may adjourn them to such time as he thinks proper. Now, importantly, a motion to adjourn is non-debatable, which means it can't be filibustered. So if it wanted to, a Senate majority could adjourn for 10 days to give the president the opportunity to make recess appointments under the rule announced in Noel Canning. But it could only do that if it got the House's consent. But if the House refused consent, then the president, working with the Senate majority leader, could use his Article 2 power to adjourn them both, and then he could make recess appointments under Noel Canning. Now, after filibuster reform, that's probably not so important because the majority that votes to affirm the Senate is the same majority that could vote for cloture and then to confirm the nominee. But there's a twist, because under the adjournment clauses, the House can do the same thing, acting in concert with the president, right? So suppose you had President Obama, a Republican-controlled Senate, and a Democrat-controlled House, right? The House could then propose a 10-day adjournment. If the Senate agreed, then that would be long enough for Obama to make a recess appointment. If the Senate didn't agree, then Obama could use his Article 2 power to adjourn them and under Noel Canning, make recess appointments. Now, notice how this provision gives the president a sliding level of appointment power dependent on his political support in Congress. So president plus one House of Congress can always make recess appointments, but president alone can always be stopped from making recess appointments. Right? It gives the House a significant role in the process, but the president's power is actually conditional on whether or not his party also controls at least one House of Congress. Now, since which party controls each chamber is largely a function of how successfully that party is engaging with the broader public, this means that the availability of the recess appointment power is at least partly a function of how supportive the broader public is of the president's agenda, or at least the agenda of the president's party, as expressed by their congressional votes. Right? So this is a way, this goes back to the discussion that we were having earlier today, of saying that not only do presidential elections matter, but intervening congressional elections matter as well. A broader democratic mandate for the president's party's agenda translates into more ways for the president to get his desired people into office. Assuming we want all elections to matter, this seems to be all the good to me. So in the end, it seems that not only is our sort of descriptive account of the separation of powers seriously impoverished when we fail to take into account the surrounding politics and the political circumstances of the day at which these political controversies become live, but that this political dynamic is also a good thing, because it allows for a system in which political actors is a function not simply of their place within the system, not simply of the history that leads up to their being there, but also of the success of their ongoing continual engagement with the public in the public sphere in a way that I think enriches notions of democratic accountability across the government as a whole. Thanks.
Get up front and we could do questions. I have some, but I'm going to wait to see how many questions we have. Questions? Or are you going to force me to go to my list? Yeah.
A non-lawyer will put a legal question to a very good lawyer, and I think I know what the consequence is going to be, but I'll do it anyway.
I'll do it.
Ron, when you set up the problem, call it, the problem of multiple texts, you did the general pairing, and then when you did the general specific pairing, I think you made the point that in those circumstances, the specific would trump the general. Okay, now, as I understand, would it be fair to say, that the recess appointments clause would be an example of something specific, and the take care clause an example of something general? Because if that's the case, then Scalia's position presumably would be that there is a clear reading of the specific clause, and therefore, by your own logic, it would trump the general and dispose of the case in exactly the way he wanted to. So have I understood you correctly, and how does that line of argument go?
Well, I sort of glossed over the definition of whether a clause would be thought specific or general. In fact, this came up at dinner last night. We were talking about the invitation of the Israeli Prime Minister by Speaker Boehner to address the Congress, to address the House. And I said that there was a specific clause, the ability of the president to appoint and recognize ambassadors, and that that ought to be seen as just barring Congress from independently conducting foreign relations. And if I recall the conversation correctly, Josh thought I was overreading the clause in terms of the specificity, and that I was not sufficiently reading clauses involving Congress's own powers to organize itself and conduct its proceedings. So I actually would suggest that they're both specific, that the take care clause is a specific duty of the president to oversee the operation of the executive branch. A general clause, I'm trying to think of other examples, but the paradigmatic examples would be the vesting clause. So if you were to put the recess appointments clause against the vesting clause of Article 2, Section 1, all executive powers shall be vested in the president, there I would say the recess appointments clause would govern. The other question, though, that I kind of glossed over and that your question brings to mind is, is the recess appointments clause itself ambiguous? And that's a major point of disagreement between Justice Breyer and Justice Scalia. And by implication, I'm with Breyer on that. Vacancies that may happen to arise. What does may happen mean? I don't view that as a self-defining term. It could mean that come into existence, but that's not what the clause says. It could mean that exist while a recess is occurring. The other question is, what is a recess? Is a recess only an inter-session recess, or is an intra-session recess of sufficient length adequate? One of the ironies of Scalia's opinion, actually, is that he puts no time limit. So if the Senate, between the first and second session, were not really to adjourn at all, if it were just to gavel out and immediately gavel in, as Teddy Roosevelt did in that microsecond between the two sessions, you could appoint any officer whose resignation was made effective upon the rising of the Congress after the first session. So in a sense, Justice Scalia's more strictly formalist opinion actually leaves a clever president with a bigger arsenal to use, because you could require all the resignation letters to say they take effect upon the end of the first session of the Congress, and in that instant, the president could then name them all. Justice Breyer's opinion, by way of contrast, requires 10 days, and he draws no distinction between an inter-session break between sessions or an intra-session break. So in a sense, I would argue that Breyer's opinion actually better honors fully the obligation of advice and consent from the Senate as a precondition of making an appointment, and as making that the normal approach. But to, again, directly answer your question, I would say that both are specific, and therefore there is a conflict, at least as presented, between the president's duty to take care. If you don't want to do that, if you resist that, and you may. I know Josh resists that. Nod. I can give you other clauses. The Commander-in-Chief clause. Could the Congress refuse to confirm Defense Department officials, the Secretary of Defense, making it impossible, theoretically, for the President to serve as Commander-in-Chief? I think the answer is no. I think there are some mandatory responsibilities in the Constitution, foreign affairs, defense, and sort of a general obligation to oversee the operation of the executive branch that the President doesn't have the luxury of not doing. Is that sorry?
If I could jump in, Ron has correctly predicted my reaction, but I just want to elaborate on it. I think it's probably not terribly fruitful to try to bifurcate general and specific, right? Clauses operate at all kinds of different levels of generality. To me, the thing I would want to say is we should read all of them in a relatively thin way. Now, that doesn't mean thinner than their words will bear, but it means not looking at the president's ability to receive ambassadors and saying, aha, that stands for a sole organ of foreign affairs doctrine or something like that. When it comes to the Commander-in-Chief clause, so Ron just said the Senate couldn't refuse to confirm generals or a Secretary of Defense, making it impossible for the president to serve as Commander-in-Chief. But of course, the Congress is the only reason that we have an army in the first place, and in fact, the only limitation put on the duration of appropriations in the entire Constitution is the limitation that no appropriations for the Army can last for more than 2 years. So in fact, the Congress is continually put in the position of reviewing whether there should be an Army at all. And I see no reason to say that Congress couldn't, as a constitutional matter, eliminate the Army. Now, as a political matter, it never would, but if it could eliminate the Army, I don't see why it couldn't decimate the flag officer ranks.
Yeah.
And so both were really interesting. And I had a couple of thoughts on both. Ron, I love your effort to really complicate and get away from the bifurcation of formalism and functionalism, which I think is really quite helpful in the separation of powers reign, because very few opinions really are one or the other, and in fact, the doctrine's much more interaction than that. I'd love to get your sense. I don't know if you recall the OLC memo on the recess appointments, and the invocation of sort of very broad claim that it would that it was necessary for President Obama to do the recess appointments, in part because the Senate was defeating Obama's control sort of over the take care duty and more general powers. I think those ones that were invoked. But the problem there is the one that the court then talks about in Noel Canning, which is it's only a residual power, right? I mean, the norm is Senate confirmation, and so to make a big separation of powers claim based on the recess, it gets a little tricky, right? And Josh, I found yours really quite interesting too. And just on a historical note, because I remember in Noel Canning coming up to that section 4 and thinking, okay, so why aren't they turning to an invocation of section 4? And it's a really interesting example of how some kinds of constitutionally provided options just are off the table. We're going to do this other thing, this recess appointment during a session. You'd think that might be off the table, but not the part so just from your historical background, has there ever been any cases that has ever sort of, was there any discussion? I just find it a big puzzle. Why? It has to be there's some political reason, right? Something that Reed wasn't willing to go along with that route or something. And I'd love to hear more.
I actually had long quotes from Virginia Seitz's opinion in the draft, but it was already over long, and the editors admonished me to take them out, which I did. But the very language you were citing was in there, alas, but trying to balance, find the virtuous Aristotelian mean between over long and insufficiently complete. It's still a work in progress. But Virginia Seitz's opinion was very interesting. I think where I break with her logic is, while I would agree that the president could reallocate responsibilities in violation of a statute in order to achieve a mandatory duty like foreign relations or defense, I don't think that means he gets to name a Secretary of Defense. It seems to me, to sort of borrow again from Buchanan and Dorff, we could imagine a series of lesser steps involving a unilateral reallocation of a duty to, say, a political appointee in the West Wing with respect to statecraft or defense that would allow the president to achieve the mandatory duty while not, as a strict matter, putting in place an officer who has not received the advice and consent of the Senate. And in terms of the larger issue, I mean, formalism is counterfactual. Was it Quayle, or someone said facts don't matter or facts are stupid things? That could be the mantra of a hardcore formalist. I mean, I think Aziz Hook basically demolished Chief Justice Roberts' opinion regarding accountability and the presidency and the effect of a double-barreled good cause removal versus a single barrel. Roberts doesn't care about that. High church formalism is about prophylactic rules that are meant to prevent problems before they arise. So the fact that the single versus double cause doesn't actually affect the operation of the executive branch is a matter of supreme indifference to a true formalist. At least that's my understanding. Now, I don't go so far. I think of myself as a pragmatic formalist, but I do think text matters. And the thin versus thick, I think where text has a pretty clear, thick meaning, we ought to stand by it. In this sense, I guess I would associate myself, and it's not a conservative liberal thing. I mean, Akhil Amar is a textualist. Bruce Ackerman is not. I, like Amar, think that we have a duty to try to give effect to text where it has a reasonably ascertainable meaning that's fairly widely accepted. Bruce Ackerman doesn't think text matters much at all, that practice and convention. He reads the text thinly, to use Josh's dichotomy, whereas I think Amar reads it a lot more thickly. And I do think formalism tends to reflect a thick reading of text more often than a thin. But the question of generality is one that we haven't really, formalists need to do a better job of explaining the level of generality at which they engage text. And also there's this trick, and your question raised it, of looking at text and using all sorts of purposive arguments that really seem kind of functionalist in their nature to build stuff into the text that just ain't there. So in that sense, the formalism-functionalism dichotomy, even from a formalist perspective, doesn't hold up. The methodology has to keep bending backwards to take into account things that shouldn't be on the table. So it is a deeply dissatisfying dichotomy, yet the court seems wedded to it. We need to transcend it more generally, but we seem stuck with it.
So I wish I had a good answer to your question. I mean, the president's power to adjourn has never been used in American history. I have had a few conversations and I've talked to other people who've had a few conversations with people who are both in the White House and in the Senate at the time. And the answers sort of break as to why it wasn't used, sort of break down two ways. Some people say that never occurred to us. Some people say it just seemed too off the wall. I mean, they don't actually use Jack Balkin's terms, but that's my translation of them. Whereas recess appointments were more familiar, and we thought it's better to have a sort of crazy detail than than have the headline be crazy. Now, I think sort of like Jack Balkin that things that are off the wall can often, sometimes even in relatively short periods of time, come to be on the wall. So I think, to the extent that we're sort of responsive to your call for sort of creativity and innovation in the sphere, I think that's something that one could make a public case for. And it would actually, especially a Democratic president could make a good case for it, because holding it up, hold up your pocket constitution, it's right here, right? That's it's going to be really hard for Republicans especially to respond to that and say, well, but historical gloss is against you. So I think it was a missed opportunity, and I haven't gotten a satisfying answer for why it wasn't used. I've just gotten a lot of verbiage.
And I agree, it could have been used. I mean, as a formalist, that's an easy question. The president has that power. The fact that he hasn't used it doesn't defease him of it. It doesn't go away. It's in the text.
We can take maybe one more question. Yeah.
So Professor Krotoszynski, I'm curious to hear your thoughts about the relative determinacy of using practice as kind of the tiebreaker when you have two specific textual commands versus like a purely functionalist approach, with, I guess two specific concerns that someone might be able to kind of cherry pick practice, sort of like we were talking about a little bit in the session after lunch, and then also just what the effect of having that be an actual very obviously set forth approach by a court would be on signaling to Congress or the executive in how they should act going forward.
Well, clearly there's the risk. I think the metaphor was raised earlier about looking across, legislative history being like looking across a crowded cocktail party for your friends. That also has been used in the context of using foreign law. A number of judges have said using foreign law is the same. I think it has to be done carefully. I will say this, that both Associate Justice Breyer and Associate Justice Scalia have fairly thorough historical examinations of the use of recess appointments, whether they were intercession versus intrasession, and whether the vacancy arose during a recess or not, going back to Washington and all the way up through the present. So I think both of them are fairly thoroughgoing opinions in terms of the way they treat historical examples. They draw different conclusions from the same historical record, and that's probably inevitable. Reasonable minds are going to disagree about how to parse a series of events. In fact, I almost want to turn that one. Actually, I'm just going to turn that over to Kirk Bradley. This is his bailiwick.
I think we're almost out of time, but no, I think that's right. It may not be. I think you're saying it may not. The problem may not be unique to this particular methodology. Lots of other ways in which the court interprets things are subject to reasonable debate, and there may be standards for doing it better and worse. And it's also one of the things that I've written about is that you find it kind of inherent in a lot of separation of powers reasoning, both within the executive and often in the courts, not inevitably so, but frequently in the courts. They find it to be a type of material that for political or legal reasons they think they need to look at in thinking about how they interpret the Constitution. Neil Siegel's back there, and we've written more recently about something that may supplement what you said, Ron, which is the possibility that, in fact, it may affect their views about whether the text is ambiguous to begin with. If you've lived with the type of tradition for a long time, the way you look at words might actually be affected by that. It may be hard to step out of your own traditions, and so there may be practice coming in whether you do it intentionally or not.
And that's Chevron too, right? The Chevron step one, part two, is to use the traditional tools of statutory construction, Cardozo-Fonseca, to ascertain whether the ambiguity is really an ambiguity in light of the full context. So I would embrace that with both hands.
Anything, Josh?
The only thing I would say is just on the fact that this is a sort of problem across methodologies, right? It's not just a problem across uses of history. People sometimes people who like the word pragmatism or like pragmatics talk as if that is a thing in the world, as opposed to a stand-in for a certain very thick set of value judgments that are going to differ even across people who claim to be equally dedicated to pragmatism. So I think that, the fact that that it requires you to make a contested and contestable judgment about material, that's just a problem, not even of legal decision-making, but of decision-making. So I'm not sure that there's much we can do about that.
Great. Well, let's thank our panelists. That was great.
Thank you for everyone who just served on that panel, and thank you for the great questions on the recess appointments clause issue from the audience. Now we are getting very close to a close. Before I invite Dr. Paul Light up here to give some closing remarks and summing up of the symposium, I just wanted to make a couple quick announcements for the participants. First, I'd like to plug the pit dinner one more time for anyone who'd like to join us. We're going to go there right after the symposium today, so anyone who'd like to join us for some barbecue at 6, welcome to come. Second, I would just like to ask any of the panelists who are able to stay for just 1 or 2 minutes afterwards, we'd really like to get a picture with all of you because we like you so much and we appreciate that you came. So if everyone who is able could come down to the front of the room when we conclude today for a photograph, we'd really appreciate it. With that, I would like to turn over the microphone to Paul Light, who's joining us from NYU's Wagner School today, and he's going to give us a summary and conclusion of what we've been talking about today, the appointments clause.
Okay. Thank you. I recognize that I am all that stands between you and the pit. So I'll be brief. I mean, this is a ton of information to suck in. As a political scientist, I heard a lot of wonderful points made, new data. I've been working on presidential appointments for a long time, and I had a huge grant back in the late 90s to mid-2000s to work on reforming the process, to make it easier for nominees to say yes. That seemed like a good thing. Just as we might choose the least unconstitutional of unconstitutional things, we ought to do no harm to nominees, unless they deserve it. So at the end of that work, I took a solemn oath with my partner, Calvin McKenzie, who teaches up at Colby, that I would never work on presidential appointments again. And luckily, it's difficult and frustrating. I continue to dabble here and there, but Cal and I sort of agreed that Ann and David, were ready to take over, and it's their 25-year journey now. So their data is very, very instructive. It's wonderful to know, by the way, that many of the things that I've said over the years without even the slightest hint of data turn out to be true. So I really appreciate Ann's comment earlier today about the data. I don't want to go into much detail. I'll be very quick here. I do want to say to my legal and constitutional experts that I was shocked to hear that there's politics in this process. People get turned out for political reasons. Of course, that's happened to many of the people in this room, and the question is how much and where it's okay. Is it all right to do that with your FBI director? Is it all right to do that with your FEMA director? Is it okay for your FEMA director to have most recently served as the CEO of the International Arabian Horse Association? Will that help him or her discharge their duties faithfully. Let me just summarize 6 quick points, very quick. Number one, what do we expect from appointees, really? I mean, how should we judge them? We've talked a lot about, well, what's the politics of appointments and, how much this, how much that. The General Accounting Office, which is now the Government Accountability Office, I testified at that hearing. There was actually a hearing on whether they could change their name or should change their name, and my response was, they do great work. If they want to call themselves whatever, let them. I mean, it was a bizarre hearing, hardly worth a hearing, and of course nobody was there. GAO released a report saying, here's a questionnaire that every president should ask their appointees to fill out regarding their qualifications to manage their way out of a paper bag. It's a questionnaire that was absolutely never used to my knowledge. I don't know whether anybody would know. What we have in the questionnaire that the Obama administration used in 2009, and I don't know whether they have amended it, cut it down or whatever, is an inventory of unbelievable personal and revealing information that must be filled out. So one of the things Ann and I were talking about is, I do agree that you start the clock when the person leaves a position, the nomination clock, but I'm interested in how long it actually takes to go from the phone call with a potential nominee to the nomination itself. How bad is that questionnaire? And I'll say that in the pantheon of really difficult questionnaires to complete, the Obama administration questionnaire is at the very top. Every URL that you're associated, there's a question in there, am I correct about this? About asking you to provide the text of any emails that might have offended somebody? I can't really remember the specifics of it. You're saying yes. Well, geez.
Embarrassing.
What? Embarrassing, yes. And there is that standard question. Is there anything in your history that might embarrass the president, the president's family, the administration? And, on the one hand, you want to advise appointees that or the president, than anybody who doesn't have something offensive that they've emailed, in the sense of saying you are, dumber than a bag of dirt or whatever, those kinds of. I mean, that it's almost like you're looking for a person who has absolutely no life, no investments, has lived in the same apartment forever, near his parents, and wants to be on the Supreme Court. I'm correct about that, aren't I? A little bit. So I really do struggle with the issue of where you draw the line, that this is just impermissible behavior, that the discharge of duties is so important that you must move this along. There is some agreement on that in the Presidential Transition Effectiveness Acts over the years that allow the presidential candidates, the nominees, to submit for early clearance before the election, I think 100 national security nominees for FBI pre-clearance. That was an effort to say, basically, there's this group of people that really matter. And on September 11, 2001, if I remember correctly, about 60% of the positions that would eventually be engaged in a response to the September 11th attacks either had no nominee pending or had a nominee who was stuck. Good, bad, just a question. So which positions really matter and how do we deal with it? Now, I disagree a little bit with which positions were streamlined out of confirmation. But I think it's a good idea to pull people out. We just need to remember that there's more than one type of political appointee. It boggles the mind to think that a schedule or a PS appointee level 4 would be replaced by a Schedule C, but I wouldn't doubt that it could happen. So we have a lot of political appointees in government who serve at the president's pleasure, and we have to be aware of how they're appointed and moved around. and how they are used to execute the law and discharge, duties under the president's direction. How many should be political? Just talked about that. We know that the number of layers in the federal government has increased over the decades. I continue to select one pitiful but brilliant student every year or every 2 years to code the federal phone book. Now, those of you who are in law school in this room, it's a delightful job, very rewarding. Merely, I don't know, 300-400 hours with the federal phone book trying to identify the stacks. And this is also part of the issue of streamlining. How should political appointees be judged came up repeatedly today, sometimes in its presence and sometimes in its absence. What are we looking for in the political appointee? Certainly loyalty to the president, but what we found in one of our studies was that whereas ambassadorships have long, 1/3 of ambassadorships have long been tightly related to campaign activity and contributions, we started to see in 2001 links between campaign contributions and executive branch posts. We really never had much problem, and I didn't hear anything in this room about it, about selling ambassadorships. I mean, what's the big deal? But we got totally upset about the idea of, putting someone in the USTR trade reps position who might have given just a huge campaign contribution. It's just a question. Now, I do have one comment about how do you measure the number of declines, and why is it that we think there are so many? One is that we talk to presidential recruiters over time, and they tell us that they're drawing deeper and deeper. They're making more and more offers with less and less acceptances. Everybody knows the true story, that the president will call you, or somebody senior on the staff will call you and say, would you like to be Deputy Assistant Secretary of Health and Human Services, which is really no longer a particularly difficult job in my estimation, because the secretaries of the departments have accreted into the secretary's suite a de facto deputy secretary operation. But you say yes, and within 24 hours you get the forms you have to fill out. And then you basically reply graciously that I don't have the time or money to fill these out. And moreover, I don't want to reveal everything, including whether I have a gun, fired a gun, and hit the target. I mean, this is a very important question. I don't think the hit the target is on the questionnaire, is it? I think have a gun, fire a gun is on the questionnaire. And what happens with these questionnaires, the National Security Form and the White House questionnaire, is that every scandal produces a new set of questions, but they're never taken off. So to this day, in filling out your national security SF 86, you must list all foreign trips made within the last 15 years, the reason for the trip, and that must include short trips to Mexico and Canada. Now, I do understand as a Minnesotan why you would be required to tell people why you went to Canada, but was it for the Labatts or Lablats, Blue, whatever. At any rate, it's just outrageous. And this is part of the issue of treating nominees, public servants, with respect and giving them, being humane at least, as you go through the process. Now, that takes me to my final point, which is this unconstitutional, the best unconstitutional option among unconstitutional. I have never heard that. And I'm so grateful to be at the Duke Law School to hear that you think about these things. And that's good, actually. I think that's good. We political scientists have now moved into mathematics about it. So it's good. And you know what? It is quite true that presidents do pick people for positions who have no business being in those positions, and both parties do it. I won't tell you which one I think is better at putting unqualified people into office, but they do slip through. I saw some of them come through at the end of the Reagan administration. Honestly, and just between us, you almost had to be an axe murderer to be denied in the last year of an administration. It's just, but let's finish with this issue of declines. The way to measure the number of declines is to look at the number of people who are moving into government from outside the Washington zip codes. The problem, you might have pets, whatever, who are going to have trouble adjusting. If you're in Washington, you have two advantages. First of all, you can wait because you have a job. And secondly, you have a job that doesn't require tenure. So many of the people going into government are now in the K Street business. They can leave, they can come back, they can move. It's not like being a CFO in a corporation. We did a huge survey of potential appointees at universities, law schools, think tanks, Fortune 500 companies, and the biggest complaint or worry among potential employees was, will my job still be there? So we think a lot about tenure. We think about ways of increasing spans of service. It's a very difficult issue because the turnover rates among appointees, which should factor into your research at some point, may now exceed the amount of time to put them in office. It's just so high, don't you? I mean, it's just really too high, and argues the question about whether we should reclassify some of the presidential appointments as career senior executive posts. That's pretty much what I have to say. I think this is a very good seminar, and I think it's a nice combination of very different perspectives. So I congratulate you for pulling it together, and I look forward to reading these papers, a third time, and trying to write something cogent about them. Is that my task ahead? Yeah, oh, that's great, that's great. I think I will, that is a figurative pet, I suppose. Anyway, it's been a wonderful day, so to the contributors here, thank you so much for your insights. I have learned a lot, and I do so look forward to what Ann and David and others in this room are going to produce in the future now that I am formally out of this business and feel confident that the process is in good hands. So enjoy the rest of your day, I guess.
Photo with all of you and your smiling faces, so please make your